I'm Chilton Varner, the president of the Supreme Court Historical Society. It's my honor and pleasure to welcome you to this next of our virtual series of lectures. Today's remarks will be made by Professor Sarah Seo, a longtime friend and supporter of the Society. I want to thank all of our members for the feedback that we have received on this pioneering effort to provide virtual lectures during the pandemic. We take seriously our pledge to our members that we will provide interesting and informative education for them, notwithstanding our stubborn virus. The responses that we have gotten to date from our members are routinely favorable. They have enjoyed them. They would love to see them continued. I think that the response has been favorable enough that we will all, in all likelihood, continue a virtual set of lectures. They won't replace our in-person lectures, but they will be continued as an addendum to increase the access that many of our members can enjoy. Today's lecture wears the intriguing title, quote, Automotive Fourth Amendment, end quote. Professor Seo is going to talk for about 30 minutes, and then we will take questions. If you have questions or comments for the professor, please submit them via the question and answer feature of your Zoom connection. Jim Duff, the Society's executive director, will review those communications and present to Professor Seo as many as we can get into our somewhat constrained time limits. Now, about our speaker. Sarah Seo is a professor at Columbia Law School. She's a legal historian of criminal law and procedure in 20th century United States. Her recent book, entitled Policing the Open Road, How Cars Transformed American Freedom, end quote, examines the history of the automobile in order to explain the evolution of the Fourth Amendment and to explore the dilemma of police discretion in a society committed to the rule of law. The book was named one of 2019's 10 best history books by the Smithsonian Magazine. It also received a number of prizes, including the Order of the Coif Book Award, the Littleton Griswold Prize from the American Historical Association, and the Ralph Waldo Emerson Award from the Phi Beta Kappa Society. In addition to publishing in academic journals, Professor Seo has written for The Atlantic, Boston Review, Lapham's Quarterly, Le Monde Diplomatique, the New York Review of Books, and the Washington Post. After earning her JD at Columbia in 2007, Professor Seo clerked for Judge Denny Chen, then of the U.S. District Court for the Southern District of New York, and later she clerked for Judge Rena Raggi of the U.S. Court of Appeals for the Second Circuit. Her CV is certainly not shabby. Please join me in welcoming our distinguished speaker, Professor Seo. And Professor, the Society's virtual platform is now yours, and we are grateful that you are joining us today. We look forward to it. Thank you.
Thank you so much for that warm welcome and for inviting me to share a little bit about my scholarship. It's a real privilege, and I've been looking forward to this since we scheduled it and put it on the calendar. And so to begin, I want to share my screen. Can you see this? Okay, great. All right. So I want to begin with a paradox. Cars transformed, or cars symbolized freedom in 20th century American culture. And my favorite example here is the Dodge commercial, which has a tagline, "Americans got two things right, freedom and cars." This symbolism was forged from the very early years of the automobile as mass production democratized mobility, as you can see in this 1911 advertisement for Everyman. According to the Ford Motor Company, women could also experience the freedom of driving, which was happening even before they gained the right to vote. But freedom is one of the most policed aspects of American life. All too familiar now is how a minor traffic violation can lead to intrusive and even abusive policing, especially for people of color. The automobile paradox raises a question. How did the meaning of freedom change in the 20th century when Americans came to expect and even accepted a great deal of policing in the very symbol of their freedom? My book examines this question through the history of the Fourth Amendment. And the title of my talk today comes from the title of a chapter in the book, the Automotive Fourth Amendment. By the end of my talk, I hope to not only answer the question about how the meaning of freedom changed, but also to convince you that the Fourth Amendment we have today is largely the automotive Fourth Amendment. So let's start with the text of the Fourth Amendment, which protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and then lists the warrant requirement and the requirements for a warrant. I focused on the Fourth Amendment because a seizure, which includes a stop of a person, as well as a stop of a driver in a car, is the first moment in a police encounter. And so it's a constitutional provision that most directly regulates the police. And the reason why I wrote about the Fourth Amendment in the 20th century and not during the founding era when it was drafted and ratified is that Fourth Amendment cases were pretty rare until the 20th century. In many years, there were none. Then the cases exploded in the 1920s, as you can see in this chart. Three developments contributed to this explosion. First is the Exclusionary Rule, which some states adopted during this period. The US Supreme Court adopted the Exclusionary Rule in the 1914 case, Weeks versus United States. And under the rule, evidence of a crime had to be excluded if it was obtained in violation of a constitutional right. So if the police discovered evidence in violation of the Fourth Amendment, then the government couldn't use that evidence to convict the defendant. Without evidence, there's no case. So this incentivized Fourth Amendment challenges. Second, national prohibition began in 1920 after the ratification of the 18th Amendment, and the prohibition on alcohol increased the number of cases that involved evidence that defendants wanted to exclude. So that also increased Fourth Amendment cases. Now, these two developments coincided with the mass production of the automobile. The Ford Model T debuted in 1908, and the assembly line was perfected for the Ford Model T in 1914. And you can see in this chart, I've circled the relevant years. 1908, when the Model T was debuted, was 63,500 cars were manufactured. That number jumps in 1914 when the assembly line is perfected to about a little over 500,000. And then 1920 during Prohibition, it jumps to 2 million. So the production and then subsequent adoption of cars exploded. So bootleggers' favorite mode of transportation was the automobile, which is essentially a movable container for hiding and transporting things. So suddenly, state and federal courts throughout the country had hundreds of Fourth Amendment cases, all raising the same question. Do prohibition agents need a warrant to stop and search a car? Judges had a hard time answering this question. On the one hand, the text of the Fourth Amendment protects persons, papers, houses, and effects. And at the time, this meant that a warrant was required to search and seize these things, persons, houses, papers, and effects. An effect is defined as a movable property, and a car is a movable property, which meant that a warrant would be required to stop a car, which is a seizure, and then to search it. But on the other hand, cars can be driven off at any time, and there wasn't time to go get a warrant. So this was a problem of a getaway car. Prohibition enforcement depended on officers' ability to stop and search cars without warrants. So some judges, like this legal analyst, argued that the Supreme Court should frankly recognize that the Fourth Amendment is inconsistent with the 18th and that the Fourth Amendment had been repealed. But the difficulty was that the rule of law required courts to uphold both the Fourth and the 18th Amendments. Both amendments were part of the Constitution. The police had to respect the Fourth Amendment, but citizens had to obey the 18th Amendment too. In many parts of the country, prohibition was very unpopular. Think about the Roaring '20s and speakeasies. And it quickly became clear that the 18th Amendment depended on greater enforcement. So the difficulty was that the rule of law cut both ways. Of course, there wouldn't be much of a conflict between the Fourth and 18th Amendments if there were no exclusionary rule. Without the rule, a violation of the Fourth Amendment wouldn't result in the exclusion of evidence. Perhaps the offending officer might be disciplined or sued, but the government could still prosecute violations of prohibition. So the issue came up most in states that hadn't yet adopted the exclusionary rule, and it came up, should we adopt the exclusionary rule or not? In 1923, the US Supreme Court heard its first car case, Carroll versus United States. And it's not too much of a coincidence that it involved bootlegging. I just mentioned that federal courts already had adopted the exclusionary rule in 1914. So what happened in 1923 was that the justices wanted to reconsider the exclusionary rule. The petitioner's brief in the case couldn't hide their surprised disappointment that the court was contemplating overruling the principle announced in Weeks versus United States, that is the principle of exclusion. So let's talk about the Carroll case, which began when federal prohibition agents recognized Carroll's car, an Oldsmobile Roadster, this model, traveling on the road between Detroit and Grand Rapids. They knew who Carroll was because they had tried to get him during a failed undercover operation a few months earlier. The agents had set up the buy of 3 cases of whiskey, but Carroll must have caught on to the scheme because he never showed up with the goods. So when the agents saw Carroll on the country road a few months later, they decided to investigate. And sure enough, they found 68 bottles of whiskey and gin in the car. Carroll and his partner, they were called the Carroll brothers, were found guilty and fined $500. And they appealed their conviction all the way up to the Supreme Court, arguing that the search of their car, seizure of liquor, and their arrest, all without a warrant, violated the Fourth Amendment. The government was represented by Solicitor General James Beck, and he agreed with the Carroll brothers that they were right about the law. So Beck made an argument that we usually don't hear before the Supreme Court. He argued that the court should change the law. So he said in his brief, the advent of the motor car requires a reconsideration of these well-settled rules of law. And let me explain what that law is and how that interacted with the Fourth Amendment. And to do that, I have to first explain how 19th century jurists and lawyers thought about constitutional law. Legal scholars today call the 19th century way of thinking classical legal thought. And according to classical legal thought, the world was divided into 2 spheres, the public sphere and the private sphere. The government could regulate the public sphere, and these regulations could also be called public rights. An example that I discuss in my book is traffic laws. Traffic laws regulate the use of public roads and highways for the public's safety. By contrast, individuals had to have the right to be left alone from the government in the private sphere, which could also be called private rights. An example is private property rights. So applying this classical legal thought to the Fourth Amendment, officers could search or seize things in the private sphere without a warrant, but the warrant requirement didn't apply to the public sphere. So for example, officers don't need a warrant to make a traffic stop to give you a traffic ticket. So the Fourth Amendment analysis began with the question, is the thing to be searched or seized in the public sphere or the private sphere? And so jurists look to the text of the Fourth Amendment, which protects persons, houses, papers, and effects. And these were in the private sphere. So any search for seizure of these things required a warrant. So a seizure of a person is an arrest, So the arrest of a person requires an arrest warrant. So it's important to keep in mind that the public or private nature of a thing wasn't self-evident or absolute. For instance, in 1928, a New York City police commissioner defended unlawful police tactics on the ground that any man with a previous record is public property. Another example comes from the classic treatise on the limitations of police power, published in 1886 by Christopher Tiedemann. And in the section on arrests, he begins with the general rule that there can be no arrest without a warrant. So that was what we talked about. But then he wrote that for public reasons, so it shifts gears to the public sphere, a person could be arrested without a warrant. And these were situations when getting a warrant would still obstruct the effectual enforcement of the laws. And so there were two main exceptions for the warrant requirement, which he states down here. He breaks it up into four, but it could be summarized into two main exceptions. One had to do with felonies, number 1 and 2 here. So basically an officer can make an arrest without a warrant if the felony was being committed, or if he had reasonable grounds to believe that the person had committed the felony. And the second exception is the misdemeanor exception, which requires a bit more from the government. An officer actually had to see the misdemeanor take place. And that meant that the officer had personal knowledge that the misdemeanor had taken place, not just belief. And in some jurisdictions, this misdemeanor exception was limited to breaches of the peace. So these warrant exceptions were referred to as the common law of arrests. Another way to view the common law is as a list of exceptions to the warrant requirement. Let me give you one more example. The home. The home is, and it still is, was and still is the preeminent private sphere. So officers have to have a warrant to search a home. But that doesn't mean that there can be no government regulation of homes. There are building codes to prevent fires, which can also authorize inspectors to enter homes to check for compliance. These laws are enacted for the public's interest. So persons and houses generally fell within the private sphere, but they can be shifted over to the public sphere to justify exceptions for the public's interest. But there was a key difference between persons and houses. An officer can arrest a person without a warrant based on his determination of legal cause, and then the arrestee would receive due process afterwards, beginning with a prompt hearing before a magistrate. In contrast, government action regarding the home had to go through legislative or judicial procedures first. Lawmakers passed building and fire codes, while judges decided whether to grant a warrant to search a home. So in Tiedemann's treatise and under the common law, there was no provision for warrantless searches of a home. So this was a common law that Solicitor General Beck was referring to when he argued that it had to be reconsidered. And the question that he posed for the court in his brief was whether the same rule which applies to a man's dwelling shall also apply to the automobile, which would mean that there would be no warrant exception. And so the alternative was to treat cars like persons, which would then raise the possibility of a warrant exception. So a house or a person, these were the two Fourth Amendment archetypes that would determine the issue. And to preview how this would continue to vex the Supreme Court throughout the 20th century, in 1971, Justice White suggested that in the interest of coherence and credibility, they treat automobiles precisely as we do houses, or treat the searches of automobiles as we do the arrest of a person. So a house or a person. So the question was whether a car was more like a house or a person, which is a weird question. As the Solicitor General put it, with the advent of motor vehicles, property has taken a form which has created necessity that has not heretofore existed. So it was a new kind of property. And so the question was, what kind of property was a car? And the difficulty was the car had characteristics of both public and private property. On the one hand, cars were private property, and for many judges, it seemed obvious that cars were private in the same ways that a home was private. Many early 20th century Americans also experienced their cars not just as a mode of transportation, but also as a new private space. As you can see in this advertisement, a car could be a drawing room on wheels. And in this hit 1905 song, the singer sang to Lucille to go automobile you and I, promising her, quote, "You can go as far as you like with me in my merry Oldsmobile." This song was such a hit that the company gave the songwriters a free Oldsmobile. So from the very earliest years of the car, people thought of them as a setting for intimate pleasures. On the other hand, cars traveled on public roads and were subject to a great deal of regulation, as this Pennsylvania court explained in 1923. They are peculiarly in the subject of government control, because otherwise modern life and society would be hopelessly imperiled. And they went on to explain that while there were natural rights to private property that existed entirely independent of government, no one had such a right to drive without permission from the state, as you can see here. That permission was embodied in the preliminary license, what we now know as the driver's license. So what the court did here was, by emphasizing the right to drive, or the way it put it here, right to operate a motor vehicle, the court shifted the analysis from a noun to a verb, from private property to individual action. And this made it easier to categorize the car under the public sphere. So whether the car was public or private made all the difference in deciding the Fourth Amendment issue. So take Justice McReynolds. He was a classical conservative who valued private rights over government regulation. So in the Carroll case, he voted for the petitioners, the Carroll brothers, because he viewed the automobile as private property, which meant that the government needed to get a warrant. 3 years later, in 1928, the court decided Olmstead versus United States, which was another prohibition case where the government had wiretapped the phones in the defendants' houses. In that case, McReynolds voted for the government. And it wasn't that he changed his mind about prohibition. He voted for the government because the opinion made clear that the prohibition agents and the wiretaps didn't trespass on the defendants' houses, so they didn't enter into the private space. On the public side was Justice Brandeis. Brandeis too understood the Fourth Amendment within this public-private framework, but unlike McReynolds, he valued public rights over private rights. He voted for the government in Carroll because he appreciated the need for government regulation of motor vehicles, which were really dangerous. They're dangerous today, but they were really dangerous at that time. A national movement on street and highway safety was going on at the very same time that the government or the Supreme Court was deciding the Carroll case. I want to note here that scholars have been confused or puzzled by Brandeis's vote in Carroll in light of his famous dissent in Olmstead. His dissent was the very first time that a Supreme Court opinion mentioned a right to be left alone, that is the right to privacy. So the question that scholars have asked is, why did Brandeis appreciate the privacy implications when the government eavesdropped on a phone conversation, but not when it searched a car? His famous Harvard Law Review article on the topic provides a clue. He wrote that the right to privacy was not absolute and didn't prohibit regulations that were in the public's interest. So he does that sphere shifting again. And also with new technologies, Brandeis feared that privacy rights were threatened, and he was a technophobe. He almost wrote in his Olmstead dissent that, quote, "With the advent of television, it will be possible to peer into the inmost recesses of the home." But his law clerk, Henry Friendly, who went on to become a well-respected Second Circuit judge, convinced him that televisions don't work that way, although I think they kind of work that way today. But back then, government couldn't look through televisions into people's homes. So this technophobia extended to cars. Brandeis hated cars, never owned or drove one. So he never came to appreciate the car as a new private space like most Americans who embraced automobility. And for Brandeis, cars were dangerous machines that had to be regulated, which meant that there was no limit on the government's right to seize and search vehicles without a warrant, which Brandeis made clear in a concurring opinion that he wrote just 2 years after Carroll. So as you can see from McReynolds and Brandeis's positions, the problem with the public-private framework was that it couldn't take into account both the public and private aspects of a car. It was one or the other. But individuals had to have some rights in their cars, even when they traveled on public roads, and the government needed to have the ability to investigate and enforce its laws. The public-private distinction offered no guidance for balancing individual rights and the public's interest. So what did Chief Justice Taft do, who wrote the opinion in the Carroll case? So what he did was he did away with the public-private binary of classical legal thought, and instead he adopted a standard based on reasonableness. After all, the text of the Fourth Amendment didn't prohibit all searches and seizures, just unreasonable ones. So rather than asking whether a car was public or private, he said the relevant question was whether the particular car search was reasonable. And Taft explained that if it was possible to get a warrant, then it would be reasonable to require one. But if it wasn't possible to get a warrant, then it would be reasonable not to require a warrant. So at this point in the opinion, it would seem that reasonableness depended on whether there was time to get a warrant. But that wasn't the rule of the Carroll decision. Taft created an entirely new rule for cars, and the holding is right here. A warrantless search and seizure of a car is reasonable and constitutional if the officer has reasonable or probable cause for believing that the automobile which he stops and seizes has contraband liquor therein, which is being illegally transported. Taft admitted in a letter to his son right here that this case created a rather new principle. Even more revealingly, in a letter he wrote to Justice Vanderventure, he wrote, "I note what you say about Brother Butler and shall try to steer away from the suggestion that we are introducing any new law, a new principle of constitutional construction, but are only adapting old principles and applying them to new conditions." So let me explain how this Carroll decision was a new rule. First, it allowed prohibition agents to stop and search a car if they believed that they had reasonable or probable cause. So it allowed the police, rather than a neutral magistrate, to determine legal cause in the first instance. Second, Carroll applied a lower standard. At the time Carroll was decided, most prohibition offenses were misdemeanors. And remember that the common law for misdemeanors required knowledge through personal observation. So essentially what Carroll did was lower the standard from knowledge to reasonable belief. So the upshot is that Carroll, instead of creating a narrow exception for exigent circumstances, it instead allowed the police to act based on their belief or judgment. And that is, it authorized discretionary policing. So one judge criticized Michigan's version of the Carroll rule, which today is called the Automobile Exception, by saying we will have officers running where no warrant could take them, speeding about in a search for probable cause, usurping the magisterial function of determining such cause. Of course, a defendant could later argue in court that there was no probable cause to justify the vehicle stop, but critics found a weak spot in the way that the reasonable standard worked. As you can see in this op-ed, it could be stretched by the holdup officer to cover any set of circumstances. And the officer's reasonable belief, account of reasonable belief would receive judicial charity. This is basically the phenomenon of confirmation bias. It was guilty people who challenged car searches. Innocent people didn't have any evidence to challenge or to exclude. And it made it easier for a judge to conclude that the officer's belief was reasonable if there was evidence supporting the officer's correct belief. An Alabama court went so far as to say that the fact that the automobile upon search is found to be transporting contraband liquors is of decided weight in passing upon the reasonableness of the search. So whether the reasonable standard would truly serve as a restraint on the police depended on how closely courts would scrutinize the police's account of reasonable cause. And the Carroll decision suggested that the courts didn't have to look too closely. The court agreed that the government had probable cause that there was alcohol in the car because the agents knew what the Carroll brothers looked like. They knew what kind of car they drove, and that they were on the road between Detroit and Grand Rapids, a well-known route for transporting alcohol from Canada. It overlooked the testimony of one of the Prohibition agents who said that they actually had no reason to suspect that the Carroll brothers at that moment were transporting liquor. As Justice McReynolds summed it up, has it come about that merely because a man once agreed to deliver whiskey but did not, he may be arrested whenever thereafter he ventures to drive an automobile on the road to Detroit. So Carroll was an important turning point. First, it shifted the Fourth Amendment analysis from classical legal thoughts, categorical analysis, so is the automobile as a category, public or private, into an individualized determination of reasonableness. Was this particular search reasonable? And second, it centered the inquiry on the officer's point of view, on his belief that the search was justified. And as the courts gave deference to the police, the Carroll decision expanded their discretionary authority. So let me fast forward to the 1948 October term, when the Supreme Court heard two Fourth Amendment cases. And the justices were clearly thinking about these two cases together, even though they were not consolidated. Both cases were argued on the same day, and the decisions came out on the same day. And it's also clear that the justices had a hard time deciding these cases because they were argued early in the term in October, but the decisions came out on the very last day of the term in June. So scholars haven't looked at these two cases together, but if we do, as the justices did, it reveals how they understood the boundary or the line between constitutional policing and unconstitutional arbitrary policing. So in the first case, Wolf versus Colorado, law enforcement officers received an anonymous telephone call about a woman suffering from a botched abortion, which was a crime at the time. Investigators found the woman, who gave the name of a chiropractor. They then raided Wolf's office, looked through his appointment book, and questioned his patients for information to charge the doctor with conspiracy to commit abortions. All justices agreed that this warrantless search of the doctor's office and appointment book violated the Fourth Amendment. The opinion explains that the knock at the door was as a prelude to a search without authority of law, that is without a warrant, but solely on the authority of the police, violated the Fourth Amendment and due process. So even though a doctor's office wasn't a house, this knock at the door certainly conjured the image of a home. And according to this opinion, this warrantless entry was reminiscent of totalitarian governments. So it says it doesn't need the commentary of recent history. Recent history is Nazi Germany. This was decided in 1949 to be condemned as inconsistent with the conception of human rights enshrined in the history and the basic constitutional documents of English-speaking peoples. So given the importance of the Fourth Amendment to a democratic society, the Supreme Court incorporated the amendment through the due process clause, meaning that although the Fourth Amendment didn't apply to the states, it was applicable to the states through the due process clause. So incorporation has huge federalism implications, but Wolf is only a semi-famous case because incorporation didn't make too much of a difference since every state already had an analogous Fourth Amendment provision in their state constitutions. The real issue in Wolf was whether the exclusionary rule would also apply to the states or would also be incorporated. The problem was this remedy of the exclusionary rule wasn't in the text of the Fourth Amendment, and I won't get into the debate here, which was really contentious, but a majority on the court decided that it wouldn't be incorporated. 12 years later, the court would change its mind about this, which I'll get to in a minute. The important point here is that the court was unanimous that the police acted arbitrarily because they searched the abortion doctor's office, a private space, without a warrant. So that was Wolf. The second case was Brinegar versus United States. And in this case, federal investigators from the Alcohol Tax Unit recognized a Ford coupe belonging to Virgil Brinegar. And I got this picture from his granddaughter, who had no idea that his grandfather had a US Supreme Court case, and she had no idea that her grandfather convicted as a bootlegger because he didn't touch alcohol in his later years. So the FBI or the federal investigators recognized him, who had a reputation for hauling liquor. He had a reputation because he had an earlier case that went all the way up to the state Supreme Court for this exact same reason. So based on his reputation and the observation that the rear end of the car appeared weighted down, the agents forced his car to the side of the road, searched it, and found 13 cases of liquor, obviously without a warrant. Okay, so it might be puzzling that the Supreme Court would agree to hear this case because according to the opinion, Brinegar was indistinguishable from Carroll on the material facts. The Supreme Court doesn't hear cases involving straightforward applications of precedent unless the justices have reservations about the precedent. And that was the case here. To most of the justices, what the officers did seemed to smack of arbitrary policing. But the problem was that Carroll had said that similar actions satisfied the reasonableness standard. So the opinion frankly recognized that the troublesome line posed by both cases is one between mere suspicion and probable cause. I was so shocked when I first read this that I had to read it a few times because this is a stunning admission that the facts in both cases might have fallen just short of probable cause. So in deciding Brinegar, the justices could either rule that the Carroll standard was wrong and overrule Carroll, or they could conclude that the application of the standard was wrong. They didn't want to overrule Carroll because requiring a warrant would hinder law enforcement too much. But some of the justices felt that if they held that the application of the standard was wrong, then that would be tantamount to overruling Carroll. And that was Justice Rutledge's view. He indicated at the first conference, and this is the conference memo, Rutledge agrees this is the Carroll case, but would overrule Carroll. And he voted to reverse. You see Rutledge in the second row voting to reverse. I want to note here also Justice Jackson's vote at the first conference. He voted to affirm the conviction. So Justice Rutledge wrote Justice Jackson a memo that if you can read the handwriting, after occupying both halls so long, he's finally come down on one, and that he thinks Carroll is controlling here. So he changed his mind. He first decided he was going to overrule, then now he's decided Carroll is controlling despite his initial views. Justice Jackson was also torn. Remember that he initially voted to affirm Brinegar's conviction under Carroll, and he was tasked with writing the opinion for the court. But his draft opinion, ended up becoming a dissent. He had just returned as a prosecutor at Nuremberg, and he declared that uncontrolled search and seizure is one of the first and most effective weapons in the arsenal of every arbitrary government. What's really interesting about his dissent is how he argued to reverse the conviction. He wrote that when a car is forced off the road, summoned to a stop by a siren, and brought to a halt under such circumstances as are here disclosed, we think the officers are then in a position of one who has entered a home. So to put some limits on the police on the road, he has to analogize to a home. But a majority of the justices didn't find this analogy so persuasive. According to Justice Rutledge, who ended up writing the opinion for the court, Brinegar and Carroll involved the use of public highways. And this did not involve, no problem of searching the home or any other place of privacy was presented. So in these situations, it was reasonable to give some leeway to the police, even if they made some mistakes. And today, courts still cite Brinegar for the proposition that in dealing with probable cause, we deal with probabilities, which means that the police can be wrong. So to sum up, the automobile fell under the public sphere, where judges would defer to the police's discretion, even if they had misgivings about it. So placing Brinegar and Wolf side by side, as the justices did, it was clear that the line between public and private, between cars and houses, mattered for deciding when the Fourth Amendment would require an officer to get a warrant. It also mattered for determining when the police's actions would be considered arbitrary or not. So the history of cars changes our understanding of the Fourth Amendment history. The standard history, it's the history that I learned in law school, focuses on the Warren Court's due process revolution, which is said to have started in 1961, when the Warren Court created a national standard of criminal procedure under the Due Process Clause. In other words, the Supreme Court began policing the police and creating more rights. And in this standard narrative of the due process revolution, the Warren Court is the protector of individual rights, particularly the rights of minorities and the poor. But I argue in my book, the standard narrative only tells part of the story, the private side. The landmark Fourth Amendment cases that extended more rights involved invasions to the private sphere, not the public sphere. I already mentioned Wolf versus Colorado, which incorporated the Fourth Amendment. The more famous Fourth Amendment case is Matt versus Ohio, decided in 1961, which finally incorporated the exclusionary rule and launched the due process revolution. And in this case, the police searched Dalry Mapp's home without a warrant, which is a classic Fourth Amendment violation of the private sphere. But there were many more, thousands more public sphere car cases where the courts deferred to the police. Over the 20th century, the reasonableness standard functioned as a deferential standard, which gave the police even more power. And from the perspective of cars, the due process revolution was not much of a revolution against the police's powers. And this mattered. In the 20th century, when American society became an automotive society, the Fourth Amendment mattered. The Fourth Amendment that mattered was the Automotive Fourth Amendment. Nearly everyone drove or rode in a car, and the traffic stop was, and it still is, the most common encounter between individuals and the police, as these quotes observed. As early as 1945, you see here the captain of the Pennsylvania State Police saying that traffic law enforcement provides many contacts between citizens and police. In 1966, a Yale law professor talks about how traffic stops are the chief point of personal contact between individual citizens and the law. And by 1997, a Stanford law professor writes that most Americans have never been arrested or had their homes searched by the police, but almost everyone has been pulled over. A poet once described the automobile as a central constitutive feature of American life. So much so that many difficult questions about the limits of the police's powers, whether or not it had to do with cars, but about the limits of the police's powers, frequently came up in the context of a vehicle or a traffic stop. And these are questions that my book covers in more detail. But let me end my talk by answering the question that I posed at the beginning of my remarks. How did the meaning of freedom change when the symbol of American freedom was subject to a great deal of policing? If we look at Fourth Amendment law, freedom didn't mean freedom from policing. It meant reasonable policing. And as judicial opinions often say when creating a new warrant exception or upholding the police's actions, reasonableness is the touchstone. That's the word they use. It's the touchstone of the Fourth Amendment. And this is a standard that the Carroll decision established for a modern automotive society. And I will end there to turn it over to Jim and for the Q&A portion of our lunch.
Thank you very much, Professor Sayo. This is a fascinating presentation, and we are going to be taking questions from the audience. If you have questions, please type them into the Q&A section, and we will get to as many as we can. And to get started, one of the images on the screen that we saw was Frank Sinatra's driver's license. Where did you get that?
The internet. The internet has lots of great images, and when you're doing a history presentation, a lot of images are in the public domain now, which is great. And also government records are in the public domain as well.
Yeah, it was great. Well, I thought that must have cost you a pretty penny if you actually owned it, but
that would be pretty cool.
You mentioned Brandeis's fear of technology, and you alluded to the fact that he may not have been entirely wrong. I mean, it was wrong at the time, of course, television's being able to peer into your home. And Judge Friendly correctly pointed out that's not how they work. But where do you see the privacy interests going in that regard when we find on our cell phones, for example, the pop-up advertisements that come very close to conversations that you've just been having with a friend? Do you see more regulation there and invasions of privacy there and trends in the law?
That's a really interesting question for me as well, because the epilogue of my book discusses briefly, very briefly, technology and this history. So one thing is that questions about privacy with modern technologies like smartphones, GPS devices, drones, all raise difficult questions about whether the public-private distinction. And the answer is the same answer that the automobile posed. It's both. People disclose so much of themselves using technology, social media, for example. The third-party doctrine says that when we disclose information to third parties, third companies like internet companies, we don't really have a privacy expectation anymore. So there's a lot of public aspects of modern technologies, and a lot of people are also advocating for government regulation of Internet of Things, of the World Wide Web, of a lot of new technologies, and so that's making arguments for the public sphere. At the same time, there are private aspects to this, right? People expect privacy in their chats, their text messages, the pictures that they take on their smartphones. So there's what the overarching theme of my book, one of the themes of my book is that in modern society, it's neither this or that. It's both public and private. And that is a really hard question, is how do courts and the law balance the public and private aspect of everything?
Fascinating. I think you're right. We will see more cases challenging those lines and testing those lines and how they're applied. Do we have other questions, Jennifer?
I just typed some in.
Okay, if you bear with me, I will look for the Q&A. I don't have them on my screen now, so if I can borrow yours for a second. Bear with me 1 second. We have all right, thank you. Question is, how did you come to work on automobiles in the Fourth Amendment?
I like to say that I became an accidental historian of the automobile. I went to graduate school to get a PhD in history to study the war on drugs. And I was interested in constitutional law, and so the Fourth Amendment, like I explained, is the main constitutional provision that governs the police, and a lot of Fourth Amendment challenges come up in the context of drug enforcement, and so I wanted to start from the very beginning. I read every single Fourth Amendment case from the very beginning through mid-20th century when they started all sounding similar, and then I was more selective about the Fourth Amendment cases that I read. And that's when I realized Fourth Amendment cases were rare until the first 2 decades of the 20th century. And that's when I realized a lot of the cases involved cars. And I think it says something about American society becoming a car society when the history of cars was so much part of the history on the war on drugs, that those two histories are connected. So I became interested in looking at the history of cars and traffic, actually, by accident, because I was interested in the war on drugs.
That's great. How, if at all, did the automotive Fourth Amendment influence application of Fourth Amendment in the private context, that is, in the home? What was the influence of it in the private context of the home?
I would say that the influence was not directly through case law informing the private side of Fourth Amendment cases, but through a social phenomena. So my book argues that because of cars and the need for traffic laws, and thus the need for traffic law enforcement, that actually was the most significant reason for the development of modern policing that we know it today. Modern policing becoming professionalized, weaponized, given increasing deference. And I think that it's the development of professionalized policing that has informed Fourth Amendment jurisprudence, even in the private sphere. And so I mentioned how the common law, there's no warrant exception for searches of homes. The first exception for hot pursuit or hot pursuit of a felon appears in the mid-20th century. And by then, definitely police are known as professionalized crime fighters. And I think it's a development, the social history of policing as a profession that affects or informs the private side of Fourth Amendment law.
Thank you. We have time for one last question here, and I will use this one. Can you make any suggestions on how your book can be used with high school students who are researching issues around driving while Black? You mentioned, I think, at the outset how it can be used in discriminatory ways.
Yes. So I love this question because when I wrote this book, I intentionally wrote in a very accessible way because I wanted students to read it. And so I do think it is readable and accessible to a high school at a high school level. If excerpts had to be chosen, I would definitely choose the introduction and one chapter. And it depends on what the teacher wanted to emphasize. Lots of students love chapter 1 because it deals with the problem about once laws are enacted, who's going to enforce them, which is a basic question that I wish every policymaker would think about when they enact laws. And this is something that I thought about with COVID when they were enacting all these regulations, no more than 6 people or 12 people in your home at Thanksgiving. I was thinking, who's going to enforce that? So the chapter 1 is really about the relationship between laws on the books and enforcement. Chapter 2 is about the history of policing, which a lot of students also like. But if the teacher wants to focus on driving while Black, chapter 6 offers a history of driving while Black.
Mm. Thank you so much. It's just a wonderful presentation and a fascinating topic. And I want to remind our audience members that you can obtain signed copies of Professor Seo's book, Policing in the Open Road, which are still available in the Society's gift shop. I'm going to hold up the book for your visual association with it. And we hope you'll purchase it. It's a very thoughtful read, and Professor Seo has given a great presentation today, and I think you'll find the book equally fascinating. We're very grateful for your time today, and thank you all for participating.
Thank you for coming and for inviting me. I really enjoyed it today.
Thank you.